In this video, I would like to talk about the difference between the writ jurisdictions of the Supreme Court and the High Court. So, the difference between Article 32 and Article 226. The difference between the writ jurisdictions of, it's a small discussion, minor changes but very important. It can be a question also in the main exam also. So, Article 32 is the writ jurisdiction of the Supreme Court. Article 226 is the writ jurisdiction of the High Courts. So, the difference is the heading. So, according to Article 32, Supreme Court can issue writs only in case of violation of the fundamental rights. So, the first point is in Article 32, Supreme Court can issue writs only, the only word is very important, only in case of violation of fundamental rights. Only in case of violation of fundamental rights. But when it comes to Article 226, the writ jurisdiction of the High Courts can issue writs even for other rights. Article 226, High Courts can issue writs even for other rights. That means Supreme Court can issue writs only for the violation of the fundamental rights, but 226 says High Courts can issue writs even for other rights. So, it can issue writs for fundamental rights and it can issue writs for other rights also. So, High Court has slightly more power than Supreme Court in this case. And then, second point is Supreme Court have no choice under Article 32. Supreme Court, it is mandatory. It is a duty on the Supreme Court to issue writs. According to Article 32, it is a duty on the Supreme Court to issue writs. If a citizen approaches the Supreme Court, it is a duty on the Supreme Court to issue writs. It cannot deny. It cannot suggest anything else. It has to issue the writ automatically. But Article 226, High Courts can suggest alternate solutions also. High Courts can suggest alternate solutions also. It may issue writ, it may not issue writ. There is no duty on the High Court to issue a writ. It can suggest alternate solution, alternate remedy, alternate remedy also. High Courts are not duty bound to issue writs. So, and then, so a third point I would like to say, even though I already said Supreme Court can issue writs only on the case of fundamental rights, so you can specifically say High Courts can issue writs for other rights, can issue writs for other rights. Then a fourth point is very clearly what we can say is that having seen both the issues, Supreme Court can issue writs only on fundamental rights. Supreme Court it's a duty on the Supreme Court to issue writs, where High Courts can issue writs on other rights also. High Courts are free not to issue writs and they may suggest alternate measures also. From these arguments which I said till now, it is very clear that High Courts have more power, have more discretion and power when it comes to the matter of issuing writs in matter or matters related to issuing writs. compared to Supreme Court. So compared to Supreme Court and High Courts have more powers in when it comes to the matters related to issuing writs. Why? That is the question. Why High Courts have more power and Supreme Court is Supreme Court is the highest court, then why Supreme Court is not having that highest power? Why High Courts are having that power? That's a very interesting question. And if I ask you, you may be thinking many things. You may say that High Courts are everywhere, AO, but that is not the reason. Reason is slightly different. The reason is something related to history, or I will say this is because of historic reasons. Something related to history. See, you please understand only one thing. In India, High Courts came up, especially in the presidency towns. The High Courts came up after the Charter Act of 1861. Charter Act of 1861 ultimately resulted in the High Courts of the three presidency towns of Bombay, Madras, and Calcutta. This was in 1860s. Subsequently, the High Court of Allahabad High Court came up. Again in 1860s. These are the High Courts more than 150 years. And whereas Supreme Court is a creation of our Constitution. Our Supreme Court, there is a federal court. 1935 Act, federal court was there. Our Supreme Court is a creation of our Constitution, and it came up only in 1950, whereas some of our High Courts are there for the last 150 years. 1860s they were created, and these High Courts were functioning similar to the High Court or the courts of Britain. And during those days, before independence, please remember, there were no fundamental rights before independence. Before independence, there were no fundamental rights, but these High Courts were there, and these High Courts used to issue writs even in those days. Please remember, these High Courts were issuing writs based on the British system. They were issuing writs at that time also. So when there were no fundamental rights also, they were issuing writs. That precedence is continued even today. That precedence is continued even today, and Supreme Court, the High Courts continue to issue writs for even other rights. They even suggest alternate measures. Even if you go to the High Court for in a particular case, they may suggest alternate measures. They may not issue writs. They may take up matters which are not fundamental rights also, because historic reason, because of the precedence, because of the history that the High Courts were there in our country even before the commencement of the Constitution. They are continuing with their historic powers. Whereas Supreme Court of India is a creation of our Indian the present Constitution. It came up only in 1950. Supreme Court has no history to tell. It is a brand new organization started in 1950 after the commencement of the Constitution. High Courts, some of the presidency town High Courts, even the Allahabad High Court and all, they have a history to tell. They were there in the 1860s. From 1860s onward they are there. So that is why these High Courts have more powers compared to the Supreme Court. So that they are continuing with that precedence, that history, that tradition. That is why they have. So the jurisdiction of the Supreme Court or rather when it comes to that, but yes, any order given by the High Court, it can be challenged in the Supreme Court. So ultimately Supreme Court's decision is final. That is okay. I am not denying that. Any order given by the High Court can be challenged in the Supreme Court, and Supreme Court's words are final. That is okay. But when it comes to the procedural power, the way High Courts can behave and Supreme Court can behave when it comes to writ jurisdiction, the High Courts enjoy slightly more powers than the Supreme Court. But otherwise, Supreme Court jurisdiction is there for the entire country. High courts have only jurisdiction within the state. All these things are fine. But when it look at the way the writs can be issued, that's what I said. Supreme Court cannot issue writs for other rights. High courts can do. Supreme Court cannot deny, cannot refuse to pick up a case. They have to issue writs, but high courts can refuse to issue writs and suggest alternate measures. Supreme Court can take up, only for fundamental rights they can take up, they can issue writs, but high courts can for other rights also. So there is a fundamental difference, and it seems, or it is, it is true that high courts enjoy slightly wider power than Supreme Court when it comes to issuing writs. That is because of historic reasons. It is not by design, it is by accident, or it is because of history, it is because of precedents, it is because of tradition that high courts enjoy more power than Supreme Court when it comes to the matter of issuing writs. Please remember this. Don't forget, this question can be asked. There may be a question in the main exam also. They may ask you, distinguish the difference between Article 32 and 226. Come up with the difference, and in that you should talk about all these things. So that's all about difference between Article 32 and 226.